All right, good morning. I'm going to call the docket. When I call your name, please say present or here. Richard Blevins. Richard B. Blevins. Matthew Boyce. Joseph Couch. Joseph Brian Couch. Michelle Daly. Randy Dobbins. Jacob Frericks. Haley Gandy. Jennifer Gonzalez. Jennifer Lynn Gonzalez. Damon Gutierrez. Damon Jacob Gutierrez. Brittany Hamilton. Roy Hamilton. Tony Hilton. Tony Leslie Hilton Jr. Mark Vargas. Here. Mr. Vargas, if you'll come up here and have a seat in the jury box for me, please, sir. Rochelle Kofer. Tristan Kimmerling. I have a note that Mr. Kimmerling has been verified in custody in the Wood County Jail. Christopher Quintanilla. Jessica Sotelo. Nesby Bostic. Francisco Shapiro. Christopher Morgan. Albert Reyna. Calixto Rosa. Calixto Rosa.
No, I spoke to him on Tuesday. He was aware of the first thing, said he was going to be here today.
Thank you, Mr. Rainer. Jacqueline Thompson. Thank you, Mr. Merleader. David McLaren. Megan Bailey. Charles Campbell. Travis Skinner. Robert Sandberg. Danny Dittman. Danny Mike Dittman. Danielle Garcia. I'm sorry, Daniel Garcia. William Ivy. Christopher Mata. Martin Perez. Martin Rosendo Perez. Candy Ray. Brandon Donahue. Leslie Gibson. Tristan Martin. Tristan Paul Martin. Thank you, Ms. Thompson. Jacob Howell. Wendy Paul, verified in custody in Kaufman County Jail. Joshua Brown. James Fields. Melba Kennedy. Eulalio Soto. Is there anyone's name in the courtroom that I have not called? Say again. Paul Cohey. Who's your attorney, Mr. Cohey? Yes, sir. Who's your attorney? Yeah, I called you. You're the very first one I called. Were you? Okay. Anyone else? All right, council, if you'll line up on the left for those that want to be first and have agreed. This being one. Okay. Okay. All right, Mr. Schmidt, are you ready?
Yes, Your Honor.
Yes, the defendant at the podium, and you can stand wherever. This is cause number CR 2136, Robert Sandberg, set for docket call today, Mr. Schmidt.
Judge, yes, last hearing, we were waiting for the former officer to turn in the photographs that he had taken and did not provide to the DA's office. I did receive those, and they were uploaded to the portal a couple of weeks ago. I know the state, sent me contact with the bank.
And Judge, we did just get in contact with the victim. There is somewhat of a language barrier, so we would ask for one more docket call just to work those issues out. We were unable to contact the victim prior to yesterday because of that.
Are you available on July 1st, Mr. Schmidt?
I don't see why not. Judge, I'm sorry.
Okay, all right. Court sets Mr. Sandberg then for an additional docket call on July 1st at 9 a.m. Once you sign that yellow copy and receive the yellow copy, you're free to go. Do me a favor. Would you bring all these podiums over? Yes, thank you, Mr. Schmidt. Carl's next. Perfect, thank you. No, I'm just kidding. You know what, I don't want to use it. Ms. Beasley, are you ready? All right, Nesby Bostic, CR 20284. All right, Mr. Bostic set for docket call today.
Yes, Your Honor. I'd ask for additional setting on the docket call. This case originally was being handled by Kansas, who's no longer with the DA's office. I spoke with Mr. Woodlock, and he and I may be able to fix resolved by the next setting.
How much time are you requesting?
30 days.
July 1st?
Yes, sir.
All right, Mr. Bostic, I'm setting you for docket call on July 1st at 9 a.m. Once you receive your notice of appearance, sign it, you're free to go.
Thank you.
You're welcome. Mr. Stevens? Are you ready on both of yours?
I am, Judge, whichever one you're gonna call first.
Brandon Donahue, CR 13435. Is Mr. Donahue entering a plea today?
No, Your Honor, prosecutor, and I, is in touch with each other. It will be.
I'm going to set it for next week on June 1st. Is this a plea to time or probation? Probation. All right.
Judge, Interesting. I'm actually over here. Do it at the jail.
No, I don't want to put more burden on the jail than we already have. June 15th.
Yes, sir.
All right, Mr. Donahue, you're going to come back on June 15th, enter your plea before the court. Once you sign your notice of appearance, receive the yellow copy, you're free to go. And Mr. Stevens, I may have mentioned this last time, but my records reflect that Mr. Donahue is delinquent almost $1,500 in his pretrial supervision fees. For me, that poses two issues. One, I may not accept the plea on the 15th. I may not allow him to go on probation. He may have to ask the jury for that. Two, seems to be a poor indicator of whether or not he's going to be able to comply with the probation conditions. So those are two things I would ask you to address with him. If there's no payment towards it, I'm very likely to reject it on the 15th.
Okay, thank you.
Now put your hand down, talk to your attorney. We're not in class. Leslie Gibson, CR 2249.
Check my class. Good morning. Looking for the aspect.
Good, thank you. CR 2249, Leslie Gibson, set for docket call.
Yes, sir. We've not recently.
All right, what's the offer in the case so that I can make a record as to what Ms. Gibson's been offered and what she's rejected?
Yes, sir. It was 12 months extension. Original offer was 15 months and they came down to 12 months.
All right, and your client understands that rejecting the state's offer means that the court will not entertain a plea to that same offer or less.
Yes.
All right, Ms. Gibson, the court's going to set you to begin your jury selection settings on June 7th. That means you're going to report to the courthouse here, 8:30 in the morning, down in the basement. If your case is not selected for trial, there'll be a member of my staff down there who will assist you with paperwork. Mr. Stevens is not going to be required to be here until he receives a notice from the court that your case is set for trial. Okay? Yes, thank you, Mr. Stevens. Francisco Chaparro?
Yeah, bro, you are.
Yes, please. Good morning, sir.
Ed King, counsel for defendant.
This is cause number CR 21-11, 12, and 13. Mr. Chaparro set for pretrial on each cause.
Yes,
Are there any contested pretrial motions?
no, not this time, Your Honor.
All right, so as the code requires, any contested pretrial motions have to be filed 7 days prior to today. So if there's a request for motion to quash, motion to suppress, something like that, there's going to have to be good cause shown as to why it wasn't filed and requested by the state. Okay, so what we'll do is we'll set this for docket call, and that will be a time that I'll request the defendant to let me know if we're going to be entering a plea or requesting a bench trial or a jury trial. And I typically set these about 30 days out. So are you available on July 1st?
Yes, sir, I should be. Judge, I'm picking up some remaining discovery today, just some media. Been discussing that with the prosecution. We don't have any formal office at this point. So
Have you already reviewed all of the discovery?
no, not all of them.
What is it that you lack?
I like the media, yes, There's some meeting rooms upstairs that pick it up, and some body cams, I'm guessing.
So really, you're not in a position to say whether or not there's a motion to suppress, because there could be
No, I'm
statements
not-
on there.
Not quite honestly, I mean, the discovery I've reviewed, to be quite candid with the court, I don't believe it to be a motion to suppress the lie.
Okay.
So I candidly tell the court that, however, if the court will give me another pretrial, I'll be completely up to speed by then.
Well, let's do this. I'll set you for docket call on July 1st. And then if in your reviewing of the body cam, some issue comes up, then you let the state know, let me know. We'll be reasonable about that. Give you a hearing if you need it.
Would that be 9 a.m. Your Honor?
Yes, sir.
Mr. Tomorrow's already signed the pass, Judge.
Once he receives a yellow copy, white one stays with me and he'll be free to go.
Thank you, Judge. Thank you.
Yes, sir. You ready on Christopher Mata?
Yes, sir.
Christopher Morgan, CR 2403. Christopher Morgan.
Judge, we just set for Doc Collins'
Hang on,
case.
let's let him get up here. So, all right,
We
go
just
ahead.
set for Doc Collins' case. We have a new prosecutor handling it, and I've spoken with the state about it. We provide new information to them, we request that we should go confident and consider that information.
All right. Are you available on July 1st?
Lisa, Judge. Yes, Judge.
All right, Mr. Morgan, court sets you for docket call on July 1st. Sign the notice of appearance, receive your copy, and you're free to go. Albert Reyna, if you'll start making your way to the podium. So CR 2132, set for docket call.
Yes, Judge, there was an affidavit filed in this case, it just arrived at our office this week. We would like some additional time to consider that, see how it will affect on the clock. I would ask for a docket call setting, and a docket call setting on this list.
No objection from the state.
No, Judge, we did just receive a, affidavit of non-constitutional late yesterday. I had a chance to review it, but I haven't had a chance to discuss.
All right, court will reset Mr. Reyna then for July 1st, 9 a.m. Mr. Reyna, after you receive your copy, you're free to go. Is Calixta Rosa here? Calixta Rosa?
Judge, I mentioned I spoke to him on Tuesday, he was aware of this thing, I have to be over to talk to him, so I just around and ask people to organize that interview, he doesn't appear, so we can get the case set.
Only concern I have with that is he's gonna get a reset if you're not here, and I'm not gonna call you back. Are there gonna be any contested pretrial motions?
Judge, we're still waiting on the discovery on one of the three cases, that I kind of like review before we accept the offer.
There's associated with it, as
Well, let's wait and see if he shows.
I've spoken to the prosecutor, he's let me know if he'll show up, maybe we'll be back this afternoon if need be.
And so I'm not making a commitment to take that under advisement at this time.
Okay.
We'll wait and see if Mr. Rosa shows up. I'll deal with him if he does. You ready on all yours, Mr. Schmidt?
Sir.
Daniel Garcia, CR 2079. All right, Mr. Garcia, set for docket call.
We're gonna ask for an additional doc call. The state, I think it's providing you with information to go over that.
That's right.
believe through our negotiations that we were just short videos, check our projections to reset.
All right, court sets Mr. Garcia for an additional docket call at his request to July 1st. And Mr. Garcia will need to sign conditions of pretrial release today, Mr. Schmidt, if he hasn't already. I have a note that says he hasn't, so. So Mr. Garcia, as conditions of bond in this case, I'm going to have you sign conditions of pretrial release. It's going to require you to report drug tests and do those things while you're pending resolution of this case. Mr. Schmidt will have more information. After you're done signing, I want you to report over here to pretrial release through this door. William Ivy, if you'll start making your way to the podium. All right, this is State versus William Dwayne Ivy, CR 19-313, 314, 315, and 316, all set for docket call today.
That's correct, Judge. We reached an agreement with the state, you guys to set this matter.
You need a certain amount of time.
Judge, it's please, as much time as you give Mr. Ivy to get his business. It's fine. You know, come back to that first. So that's all.
State.
Whatever time is convenient.
Okay, all right, so court will give Mr. Ivy till July 1st to enter his plea. I haven't dealt with the Cody guy yet. Oh, so you still want to leave and come back on 15? Perfect. Hey, it's good when they show up sooner rather than later. Justice been like, okay, thank you. Yes, we'll set that at 1:30 at the Vanzant County Justice Center. Thank you for that. I'm sure Sergeant Carter appreciates that as well. Christopher Mata. It's a CR 2261. Set for docket call.
It is, Judge. Well, I started this docket call. I think that, so I like to- we'll get the call, but we, it's not like,
Sorry, I'm waiting for my system to pull up here. Here we go. Any objection from the state on Mr. Mata's request for an additional docket call? All right, court sets Mr. Mata then for docket call on July 1st, 9 a.m. Ms. Ray, if you'll start making your way to the podium. CR 13161, State versus Candy Lee Ray. Hearing on motion to revoke, I believe.
It is, Judge. I have the state has tendered to me a motion to withdraw the MCR and terminate this race. Community supervision, I know that the court was hesitant to proceed on that. Waiting this race. Taking care of for indigent defense groups for my services.
Was Ms. Ray the one that bonded out on the personal bond?
That's correct.
Have you had that discussion with your client at all about her repayment of indigent fees?
Judge, just to give you no reason to come back.
Did you have talked to her about it? Oh, yeah.
I do know that recently Ms. Ray was able to take her financial resources. So
Can I have counsel approach? Yeah, do you want it on the record? All right, we're back on the record, CR 13161. The court will take the state's motion to withdraw the motion to revoke or adjudicate under advisement. We'll reset this case for 3 months. And court would expect Ms. Ray to become compliant on her financial obligations in that time. The court And this is by agreement, correct, Mr. Schmidt?
It is, Judge, and I would, tell the court that I intend to submit the bill for my fees and $350 so that she's aware of what her obligation is going to be. She's informed me that she can take care of that. With that.
All right, court will set this for July 27th, in case she can't do it in a month or doesn't do it in a month.
Is that good?
July 27th. Did Martin Perez appear? Martin Perez here. Does that conclude you?
I think you said that, Mr.
Dittman?
Ball's in custody. We also have Danny Dittman. He's,
Is Danny Dittman here? Danny Mike Dittman? And who did you say was in custody? Oh, Mr. Weiner's on that case.
I think what we did, what we've done, is she had a couple of days pending in the report. She had a felony pending. Judgment for actually approved the month as a whole. It's possible that I didn't get somehow.
The other two. Okay,
So that's later.
okay. I'm showing Mr. Weiner. He's on his way.
I think that's all right.
And I believe that she's going to be. No, I'm mistaking that for another case. So, Ms. Thompson, are you ready? Did he arrive? Tristan Martin. CR 2180. Mr. Martin, you were late. You're lucky that Ms. Thompson stuck around. I'd already made a note to issue a warrant. If she would have asked to leave, I would have let her leave, and then you would just gone into custody today. So you better be thankful that her willingness to wait for you. Go ahead, Ms. Thompson, set for docket call.
Yes, sir, we have a plea agreement worked out that I was only able to discuss with Ms. Martin this morning. When you want to accept it, what you need to do that.
Do we want to do a waiver of jury trial at all?
Yeah, I'll do it.
Okay, if we can get that done, State, if you can assist, then we'll bring Mr. Can we do that pretty quickly, Mr. Woodwhite? Thank you, sir. I don't mean to put you on the spot. Let's look at our calendar while we're waiting on that. About how, is this a plea to time served, TDC probation, time served? Is Mr. Martin going to be paying any of his fines obligations up front?
Good news.
How does July 1st look?
July 1st is open.
Can do that. All right, so let's go ahead and set Mr. Martin for plea on July 1st, and then Mr. Woodwhite's going to bring us this waiver of jury trial. Are we ready to proceed on that one?
Yes, Judge.
Jacqueline Thompson, CR 16447. All right, Ms. Thompson, this is a hearing on your motion to revoke. Go ahead, Mr. Murray Leader.
Judge, I will take it.
All right, Ms. Thompson, if you'll raise your right hand. Ms. Thompson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. All right, Ms. Thompson. It appears that you were before the court, let me get back into it. You were before the court on February 7th of 2017 and pled guilty to the charge of prohibited substance or item in a correctional facility. Court heard the evidence at that time, found that there was enough evidence to convict you, but the court deferred a finding of guilt in your case and placed you on community supervision for a period of 3 years. And I believe that you were also extended during your terms and conditions of your community supervision. The state did file a motion to adjudicate your guilt and revoke your community supervision on May 20th of 2021. Have you had an opportunity to review that document with your attorney, Mr. Murray Leader? Mr. Murray Leader, does your client waive the formal reading of the state's amended motion to adjudicate?
Yes, sir.
And is it her intention to plead true to counts 1, 2, 3, and 4?
That's correct, Judge.
All right, and you believe your client to be competent today, Mr. Murray?
Yes, sir.
All right, so Ms. Thompson, are you pleased with Mr. Murray Leader's representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him, have all your questions answered?
Yes, sir.
All right, so Ms. Thompson, I'm going to ask you at this time, how do you plead to counts 1, 2, 3, and 4 as contained in the state's amended motion to adjudicate? Are those counts true or not true? And are you pleading true to those counts because those counts are true and for no other reason?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead true today?
No, sir.
All right, the court will accept the defendant's plea of true in this case. Mr. Murray Leader, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A? All right, State's Exhibit A is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, from the defense? All right, the court, upon hearing and reviewing the evidence, finds that Ms. Thompson has violated the terms and conditions of her community supervision. The court will follow the plea agreement that the defendant has reached with the state. The court, upon finding that she has violated the terms and conditions of her community supervision, hereby adjudicates her guilt, convicts her of the third-degree felony offense of prohibited substance or a prohibited substance in a correctional facility. The court assesses her sentence for that at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence and place Ms. Thompson back on community supervision for a period of 1 year. The court will order her to pay the balance of her financial obligations. All right, Ms. Thompson, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Office so they can carry out the terms and conditions of the sentence. And have you come forward, be fingerprinted with the deputy, and then report to probation. Joe, this is hers. This is for her to keep. It's her bill of cost. Yes, thank you, Mr. Murray Leader. Mr. White, are you ready?
I'm ready. Free of mine, another one.
Who's the other one?
Mr. Soto was paid.
He's the other one. Joshua Neal. I'm sorry, Joshua Neal Brown, excuse me. Mr. Murley, come. Your center stage. All right, Mr. Brown, this is CR 2379. Show that we're set for status today, Mr. White.
Yes, I probably. It's going to be whatever. I talked to Mr. Wood, he is requesting that. I know this one had no flights. And DPS hasn't got that. He indicated.
That's correct. Since we made a request in November, I made another one in March. Fortunately, this time, I will consider a little more impression on this.
Is it that we're waiting a test or are we waiting information from the lab concerning the blood test? So we already have the lab, but you're asking for underlying information? Okay. All right. Court will reset Mr. Brown for an additional status on the blood evidence. You available on July 1st, Mr. White? Okay. We'll set Mr. Brown then for status on July 1st at 9 a.m. Mr. Brown, once you sign, you're free to go. Mr. Fields, you'll start making your way to the podium. This is this is 2020-607 State versus James Ethan Fields. Go ahead, Mr. White.
Your Honor, state not which. That's just. We can do it. We have a G15.
We do. Okay. Court will set Mr. Fields for plea June 15th at 1:30 at the Van Zandt County Justice Center. Melba Kennedy, if you'll start making your way to the podium. Melba Kennedy, CR 1959, CR 2171, CR 2257. Show Ms. Kennedy set for docket call on her two newer cases and the motion to adjudicate or revoke on the older case.
This kingdom is going to be. I would ask.
On July 8th. Any objection from the state?
No.
All right, we'll set Ms. Kennedy for plea on July 8th at 1:30. Yes, sir. All right, Ms. Kennedy, once you sign and get your yellow copy, you're free to go. And so just Mr. Soto, just let me know, Mr. Soto. Oh, you ready? Eulalio Soto, CR 20369. All right, Mr. Soto, if you'll raise your right hand, sir. Mr. Soto, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Your name is Eulalio Jason Soto, whether I'm pronouncing it right or not. Is that your name?
Yes, that's pretty close.
Okay. And Mr. Soto, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White's representation of you? You feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Mr. White, do you believe your client to be competent today? And have you explained to him all of the law regarding the pretrial intervention contract?
Your Honor, I would, Mr. Soto. Explain the way this is trial. I'm satisfied. Diligently, voluntary.
Thank you, Mr. White. Court will, in open court, approve the waiver of jury trial in this case, as it is joined by counsel for the defendant and counsel for the state.
Yes, sir.
Mr. Soto, there's a document called waiver of speedy trial and limited waiver of expunction. Can you show him that, Mr. White? I'm going to swear him on this one. Just ask him if that's his true and correct signature. All right, Mr. Soto, you're asking the court to allow you to enter into the pretrial intervention program on the charge of possession of a controlled substance in penalty group 2 greater than or equal to 1 gram, but less than 4 grams for a period of 2 years. Do you understand that if the court approves this contract, that you're going to be waiving several important rights, and you're also going to be stipulating to the admissibility of evidence should you violate this program and end up back in court? Do you understand those things?
Yes, sir.
And you're asking the court to approve that here today?
Yes, sir.
And you've read over this contract and you understand everything that you've reviewed and signed along with your attorney, Mr. White, correct?
Yes, sir.
All right, court's going to approve Mr. Soto for the placement into the pretrial intervention program for a period of 2 years. All right, Mr. Soto, I'm gonna have you, you can get your personal belongings if you have any with you, and then I want you to report to the pretrial release department and pretrial intervention program through this door here, okay? Thank you, Mr. White. Mr. White.
This price, I believe it's-
Have you seen the indictment in that case? Mr. Vargas, if you'll just come around here next to Mr. Schmidt here. That's fine. All right, this is cause number CR 29-4, State versus Mark Henry Vargas, set for arraignment. Mr. Vargas, the court has reviewed your affidavit of indigency, finds you to be indigent. Court has appointed the Honorable Richard Schmidt to represent you. Mr. Schmidt, have you had an opportunity to meet with your client this morning and go over the indictment in this case? And are you ready for arraignment?
We are ready, we have gone over it. Mr. Vargas' name is spelled correctly. And that stands what we started. Today, we're only reading.
All right, court will find that Mr. Vargas has waived the formal requirements of arraignment, will enter his plea of not guilty into the record. And the court will set this for pretrial on July 1st at 9 a.m. July 1st. Mr. Vargas has a warrant for his arrest. I'm not sure what it is, but it's been confirmed. So he'll be taken into custody at this time. So you just want to do it today? Okay. I don't mind at all. Adam's ready. I saw this younger guy over there that looked like you without the beard, and I was hesitant to call your name. Thought it might be a doppelganger or something. Does it help? Does it work? Let me know if it works. 'Cause if it does, I'm going to shave mine. Are you ready on all of yours? All of them that are here anyway. Rochelle Kofer. CR 20285 and 320. For a chance to get up here. Show Ms. Kofer set for a docket call today.
Yes, Your Honor, from reviewing my file, it's become apparent to me since the last time here that I do not have audio or video in this case yet. Or if I did, it's possible that I had it and that I worked from and placed it. So I requested Ms. Abney over at the district attorney's office, give me a copy or a new copy. I'll be picking that up today. And so what I'm asking the court for is a reset to give me the time to obtain, review the audio or video footage, and decide to decide what to do with the case based on that.
Any objection from the state?
No, Your Honor.
Okay. Court will set. Are you available on July 1st? That's kind of the date I'm rolling everyone over to.
Okay.
All right. Court will set Ms. Kofer then for an additional docket call on July 1st on each case at 9 a.m. Ms. Kofer, once you sign and get your yellow copy, you'll be free to go. Christopher Quintanilla. CR 2131. We're doing a plea today on Mr. Quintanilla.
Sorry,
We're doing a plea today on Mr. Quintanilla. You may. Sir. All right, Mr. Quintanilla, if you'll raise your right hand, I'm going to place you under oath. Mr. Quintanilla, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Your name is Christopher Dylan Quintanilla, is that correct? And Mr. Quintanilla, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Feel like you've had enough time to discuss your case with him, have all of your legal questions answered? Anything about this paperwork that you've reviewed and signed today that you do not understand? Mr. Adams, do you believe Mr. Quintanilla to be competent today?
He's competent, Your Honor.
And have you explained to him his legal and constitutional rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir. All right.
All right, Mr. Quintanilla, you're charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram, which carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice, and also an optional $10,000 fine. If the court approves the plea agreement that you've reached with the state in this case, in which you would be pleading guilty to this charge in exchange for a recommendation that you be placed on 3 years community supervision and a $4,000 fine, along with court costs and restitution and reimbursement fees. If the court approves that, if you are on your community supervision and you violate, and the state proves that you violated that, the court could adjudicate your guilt, find you guilty of that charge, and assess your punishment anywhere between 6 months up to 2 years. You understand that? You want to go forward with the plea in this case? Mr. Quintanilla, then understanding your charge, how do you plead to the possession of controlled substance in penalty group 1 less than 1 gram? Are you pleading guilty because you are guilty and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt in this case. Mr. Adams, any objection to states 1? States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we address it.
Thank you, Mr. Adams. All right, Mr. Quintanilla, based on the court's review of the evidence, I do find that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in your case. The court will defer a finding of guilt, place you on community supervision for a period of 3 years, orders you to pay a $4,000 fine, court costs of $290, orders you to pay reimbursement fees of $535, and restitution of $180. Mr. Quintanilla, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted here. After that time, report to Ms. Burns. Will you help me? Jane?
Oh, Your Honor, one thing, the silver line, there's a an unfiled possession of marijuana case. Discussed yesterday, it's my understanding, so, it's to require constitution.
It is, that is a state's understanding of our.
It's on the record.
That's it.
All right. All right, Mr. Quintanilla, if you'll walk up here, she's gonna take your fingerprint. Let's talk about Tristan Kimmerling. I've got him verified in custody in Wood County. You have any information on that? And this is CR 2293.
No, I don't know. That's my understanding. It's still there. I think the county, or maybe the breaking up. Online database. I'll make a note of myself.
We'll go ahead and reset him for status on his custody to that same date, July 1st, and we'll just keep a track on him. Jessica Sotelo. Ms. Sotelo is set for docket call today.
Yes, sure. Ms. Heisel and I don't think yet concluded our plea negotiations. Having Ms. Heisel, there might be an alternative to offer. She's not in a spot at this moment where she can express to that. And so I think that if we recess on the 1st of July, we'll come back.
Yeah, our offer is highly contingent on her CPS case, so I need to get an update on that before I can say yes or no to the counter offer.
Okay. Court will grant the extra time and we'll reset Ms. Sotelo for docket call on July 1st at 9 a.m. Mr. Sanders, are you ready?
Yes, all right.
Is that all you got?
That's all I have.
You may. Travis Skinner. CR 2226, CR 265, set for docket call. Go ahead.
Hey, Judge, we've been waiting on toxicology results and we're still waiting on those. But also talking with Ms. Heisel, I think we might be getting close to where we could possibly reach some kind of resolution on this. And so we were asking to have one more doctor call. It's live for today or something like that.
Just for the board's record, what we're waiting on is blood toxicology of the victim. From the night I have been notified by the lab that it has been signed indicated to them that it was very important that we get this as soon as possible. So we are very hopeful that we'll know something by July.
All right, court will reset Mr. Skinner then for docket call on July 1st, along with the status on the toxicology. Charles Campbell. This is CR 2110, State versus Charles Nicholas Campbell, set for docket call.
And Judge, Mr. Campbell's case, I was gonna have to, one more docket call setting. He's out of jail now, so it makes it a little easier to sit down and talk through everything, go through all the discovery. And Judge, I believe that by the next docket call, we'll have some.
All right, court will set an additional docket call for July 1st at 9 a.m. Megan Bailey. CR 2378. Set for docket call as well.
Yes, sure. And Ms. Bailey, just talking with the state, we have an offer that I think that she's seriously considering it involves some time in county jail. I was going to ask if we could reset it just a couple of weeks for the docket call. And we have a decision at that point, like June 15th, if that would work.
But not for plea, just for docket call.
Well, it would either be a plea that day or we have it set on trial.
Would it be a plea to time or probation?
Time. It would be, so the offer is 60 days on 1244A. And so if she would have accepted it, she understands, I told her that expect to go to jail that day. If you're gonna accept that.
Yeah, my only concern with doing it that way is if I bring her back on June 15th and I set her in the afternoon and she doesn't do it, then I'm overcrowding the jail court with non-jail people. And likewise, if I bring her back in the morning, then I put a burden on the sheriff's office to have to transport between over the lunch hour. So
Would work if we had it set from the morning, and then if we knew for sure it was gonna be a plea, then just reset it to the afternoon to do the plea there at jail.
how long has she had the offer? How long does she need to think about it? Oh, since yesterday. What about, what about June? What about next week, June 1st? What about Tuesday, till Tuesday? You're available?
Yeah, yes, that might be. Well, I can set that morning, but I will be over here in the afternoon.
I've got less people set that day, I believe. I'll tell you what, let me look at my system real quick to see how many people we have set for the afternoon. coordinator who knows all and makes all happen. On her expert opinion and advice. What about June 29th? Our other dockets are June 15th and June 1st, or we're at max capacity.
I think. Well, the 9 o'clock would work.
It'd be 9 o'clock. Well, I mean, we could set it for either or. That's an evidentiary day in our docket. We have less than 20, so we could set it for either one that day. We wouldn't have a jail court that day. Everyone would be, any inmates would be brought over here. So we could do either or.
Okay. Yeah, if 1:30 would work, I'm gonna be getting back, I think the day before, out of state. I think that's fine for that. So,
Sure.
it's Tuesday.
It's either that or we just go ahead and bump it over to July 1st. That way, if you're trying to get caught up,
But actually, if of course, okay with doing that, that
let's just do that.
might be easier.
Let's just do that. Let's just do July 1st and we'll just do it in the morning. We'll do it in the morning, and if she wants to go in custody that day, then we'll figure out how to may give her the ability to be released and report back at 1:30. Okay. All right, so Miss Bailey, the court's going to reset you to July 1st for docket call at 9 a.m. That's fine. Just appoint who you can and I'll.
She's here, she's got.
Okay. All right, Mr. Sanders, who else do you have? Anyone else? Haley Gandy. Haley Gandy. CR 2165. All right, Ms. Gandy, the court's reviewed your application for court-appointed counsel, finds you to be indigent today, appoints the Honorable Jeff Sanders to represent you. Mr. Sanders, have you had an opportunity to meet with Ms. Gandy and go over the indictment in this case, and are you ready for arraignment?
Yes, sir, we are. We had a chance to review the indictment. Her name is spelled correctly. Just we would waive the formalities of arraignments. Spelled correctly. We've gone over the punishment range for the state jail felony charge, and we didn't plead not guilty at this time.
All right, court will find that Ms. Gandy has waived the formal requirements of arraignment. Court will set and will enter Ms. Gandy's plea of not guilty into the record, and will set pretrial in this matter on July 1st at 9 a.m. Ms. Gandy, have you seen your conditions of pretrial release? Okay, so you understand that you have to report to your pretrial release officer, you have to drug test, you have to pay towards the court-appointed attorney that's been provided to you? Okay. Once you receive the yellow copy that you signed, then you'll be free to go. Have you talked to her? Ms. Gandy, before you leave, you can get your stuff. Before you leave, I want you to come over here and meet with Mr. Waddell, the pretrial release officer, okay? Is that the only one you were appointed on?
Yes, sir. That's all.
All right. Okay. You may.
That's the receipt, you know. The probation department can have remit the 350 to whoever it goes to, but that's where she paid it, so they accept it.
Yeah, they'll remit it to the clerk. Yeah, that's perfect. Okay, that's good. All right, court recalls CR 13161, Candy Ray. All right, Ms. Ray, the court finds that you have satisfied your financial obligations for the reimbursement of attorney fees in the amount of $350. The court this day is signing the order granting the state's motion to withdraw, the motion to revoke, and to terminate your community supervision. You're free to go. Mr. McLaren, I'm going to call one more on Zoom. We're going to give Mr. Pappas an opportunity to get connected to audio here. Good morning, Mr. Pappas. I'm going to ask you to unmute. I'll send you a prompt there on your.
How is that?
Excellent. Good morning, sir. Can you see and hear me okay?
I can. How are you, Your Honor?
Doing fine, doing well. Mr. McLaren, if you'll raise your right hand, can you see your client there, Mr. Pappas?
I can.
All right, you can put your hand down. All right, this is cause number CR 2263, State versus David Wayne McLaren, set for pretrial today. Any contested pretrial motions, Mr. Pappas?
Not at this time, Your Honor.
All right, there being no contested pretrial matters, the court will set this for docket call. Do you have your calendar available? Are you good on July 1st, Mr. Pappas?
I am.
All right, Mr. McLaren, the court's going to set you for your next setting for docket call on July 1st. That's when the court's going to want to hear whether or not you're going to enter into a plea agreement or request a bench trial or a jury trial. We're going to sign notice of appearance today. And Mr. Pappas, I'm going to order your client to go over and present himself to the Van Zandt County Justice Center so that they can fingerprint him, so that they can get a state tracking ID number that they need to report to DPS. It'll be a book in. You won't be booked in and booked out. They'll bring you back. They'll take your fingerprints electronically, and then they'll send you on your way. Okay. So I'm going to order you to do that. I'm going to send you with an order. So you go over there, present that, and they'll get your fingerprints, and they'll get you in and out as quickly as they can. Okay. Hang on just a second. All right, Mr. McLaren, I'm going to have the deputy bring you a copy of this notice of appearance. I want you to sign there on the X, and then we're going to give you a yellow copy. I'm sorry, Joe. You'll give that to him. Here's this order that you're going to take to the jail. So you're going to get the yellow copy, you get that order, and then you'll be free to go. And then just go out to the Justice Center. You know where that is, out on Highway 64. Like you're going back towards I-20. So when you leave the courthouse, you'll go west on 64, and it'll be about a mile out on your right.
Excuse me, Your Honor.
You sure?
I have a TRN and I have an offense date and I'm arrested.
Yes, Mr. Pappas.
I just didn't know if the file that you have reflected which prosecutors assigned to this case.
No, I don't have such thing, but the
Find that out, Judge.
here. Well, the prosecutors are here and they can hear you. He wants to know which one of you prosecutors can be handling the case. Did you hear that? It's Tyler Woodwike. Mr. Woodwike said that he's going to be.
Okay.
handling the case.
Great. I'll give him a call. Thank you, Judge.
All right. Thank you, Mr. Pappas.
May I be excused, Your Honor?
Yes, sir. So you're sir. Mr. McLaren, if you'll approach. They stuck the order behind my docket, but it doesn't note on here to go get it. So apparently, they have gotten your fingerprints. Have you gone out there and been fingerprinted at the jail?
Not even, I had some stuff done in Denton and I got arrested on the warrant.
Yeah, okay. Well, they're saying that they have it now, so just give me that order back and then you're not gonna have to go. You're free to go. They said they got what they need, so you're good to go. All right, thank you, Mr. Clarence. Have a good day. Yeah, go ahead, grab your stuff. We're coming back on Mr. Vargas or someone different? All right, Mr. Vargas, I'll tell you what, just stay where you're at. Stay where you're at. All right, we're back on the record, CR 29-4, State versus Mark Henry Vargas.
Yes, Judge. Looking into the issues currently with the surrender principle on this Vargas bond, the bail bonds result in Texas. Seems to me like they jumped the gun, obviously, it's which would say. I've talked to the state, they agreed to $10,000 PR bond on this, Vargas. The other issue though is that Deputy Carter is trying to confirm the warrant so far as I'm unable to do that. So procedurally, what I would ask, and I don't know whether if they determine that there is an active warrant to clear it and have a PR bond on file at the same time, like local lines. So just wanted to make sure, I mean, if we can prevent transporting them, then we would like to do that. Obviously, save everybody time and money. But from a procedural point of view, it's certainly not a comment.
Yeah, I show that Mr. Vargas was originally bonded out by Roy Brockway on a $10,000 bond. They did a 1719 release of surety, and that was granted by the court in sometime back, it looks like.
It's my understanding that Mr. Vargas a Davis fell laws after the fact. So he should have a bond that if they haven't seen it, and I haven't seen this one now that I realize that this is from Mr. Nicholas. So this one made it clear by bonding out with the Davis fell laws. After this.
Yeah, I'm viewing the clerk side. What I can't see is the Justice Solution side. Are we having any hits for any other warrants? I don't show any release of surety for Davis bail bonds. So his bond should be good, but is there a warrant showing for any other offense not related to this?
No, sir. The warrant he's got active for him right now is for a surrender of principal on a controlled substance case. I don't think it's going to be this case.
You don't think it's going to be this case?
I believe it's going to be this case.
Oh, you think it will be this case?
Judge, I think that based on the hearing, it sounds to me like the sheriff department didn't clear the surrender.
In the system, he's showing flaws. I'm gonna pick it on TCIC, showing why they can't lay their hands on the original document in-house over there. And it's from July of 20.
That's correct.
All right, so Mr. Vargas, I'm going to release you, but I want you to know that if you get stopped, they're probably going to take you into custody because it's going to show some type of, it's going to show a warrant, same thing that's showing today. So you need to be very careful. I don't show that you do have a surrender of principal warrant related to this case. I show that you did have a surrender. I'm sorry, you did have a release of surety warrant that was granted by the court for failing to comply with their conditions of the agreement. Court signed that warrant. You were rearrested. Obviously, you know these things. And that you were then bonded out by the Davis bail bonds in Uvalde on a $20,000 bond. So I believe that based on what I review here, that bond is still good. So I'm gonna go ahead and release you, and we're gonna send that information back to the sheriff's office to determine if that information needs to stay on the system or not, and have them tend to it if not. But when I release you today, there's still a good chance that that's gonna be on the system for, could be a day or two. So you need to be very careful if you have an encounter with law enforcement, it's likely to be taken in on it. Okay, so you're free to go.
Thank you.
Mhm. Richard Blevins. This is CR 16397. Mr. Blevins, a motion to revoke your community supervision has been filed by the state on a second-degree felony charge of aggravated assault with a deadly weapon. Do you intend to hire an attorney to represent you? You have applied? Did you apply this morning? Okay. Okay, just have a seat. I don't have that paperwork back yet, so just have a seat and I'll call you back. Jacob Frericks. Am I saying that correctly? All right, Mr. Frericks, you've been charged by indictment with the state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. You're set for arraignment on that cause today. Are you going to hire an attorney to represent you? And when are you going to hire that attorney? You believe that you have the ability and finances to hire an attorney, and you will get that done in the next week or two? So if I reset you to come back another day, you'll come back with a lawyer? All right, Mr. Frerichs, I'm going to set you for June 29th. All right, Mr. Frerichs, the deputy here is going to bring you this form. You're going to sign here at the X, and we're going to give you a copy saying that you're going to come back on June 29th at 9 a.m. You're free to go. Ms. Beasley, are you ready? Have you been appointed this morning?
Yes, Your Honor. Matthew Boyce, 309 CD.
Mr. Boyce? All right, this is CR 16-395, CR 17-399. Each case set for arraignment today. The court has reviewed Mr. Boyce's application for indigent counsel, finds him to be indigent, has appointed the Honorable Deborah Beasley to represent Mr. Boyce. Ms. Beasley, have you had an opportunity to meet with your client today and review the indictments? And are you prepared for arraignment?
Yes, Your Honor, I have. I've gone over each indictment with my client. He understands the range for state jail offense. His name is spelled correctly, wishes to enter a plea of not guilty to each of the charges.
All right, the court will find that Mr. Boyce has waived the formal requirements of arraignment and will enter a plea of not guilty in each case into the record. And we will set Mr. Boyce for pretrial. On July 1st at 9 a.m.
May he be excused, Your Honor?
Yes, Mr. Boyce, have you signed your conditions of pretrial release?
Yeah.
You have those?
That's not that. I'll check.
Okay, I just want him to sign his conditions before he leaves today. Thank you, Ms. Beasley. Randy Dobbins. All right, Mr. Dobbins, you're charged by indictment with a third-degree felony of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams. That carries a range of punishment of not less than 2 years or more than 10 years. Have you requested court-appointed counsel, or are you going to hire an attorney? Have you applied this morning? Why not? I understand, but I know that my coordinator, Ms. Taperham, has been in here about half a dozen times announcing that if you want a court-appointed attorney, you have to go see her and fill out paperwork. Were you here at 9 o'clock? I mean, I called your name and I checked you off. I know she came in at least half a dozen times. All right, step out in the hallway, go down to the very end, office on the left, speak with Patty Taperham. Okay, thank you. Who else is requesting a court-appointed attorney but has not filled out the paperwork? Has not filled out the paperwork. Roy Hamilton. All right, Mr. Hamilton, this is cause number CR 2171. You're charged by indictment with the first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. It carries a range of punishment of not less than 5 years or more than 99 years or life, and a $10,000 fine. Mr. Hamilton, the court has reviewed your request for court-appointed attorney, and based on the information you provided, you do not qualify under the law for a court-appointed attorney. So what I can do is I'll reset your case and give you some time to hire an attorney. Say it a little bit louder. What? I'm not sure about any of that. That's the facts of the case are beyond me at this time. So what I'm going to do is I'm just going to reset you until July 1st. Okay. And then either you can hire an attorney to track down that information that you've given me, or you're just going to have to make that decision for yourself. But I'm going to expect you to be back here on July 1st. And if this case is not dismissed by the state before then I'm going to expect you to have an attorney with you on that date. Okay. All right, Mr. Hamilton, the deputy is going to bring this form to you. I'm going to have you sign right there, and it's going to have your new dates on that. Once you get the yellow copy, you'll be free to go. This is CR 2170. Ms. Hamilton, you've been charged with the state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram. It carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC and a fine not to exceed $10,000. Are you hiring an attorney to represent you? And when do you think you're going to have that done?
Before, at least a month.
Do you know who you are trying to hire?
Yeah, I probably. My family for it.
All right, so if I reset you to July 1st, you feel confident you can have an attorney back with you on that date?
If I feel, before, then I will try it and. I'll go here.
Well, you know your finances. Are you able to hire an attorney?
My family is, so I'm gonna ask my family.
Well, when you come back on the 1st, I'm going to expect you to have a lawyer. I don't want to give you 30 days for you to come back and say, hey, judge, now I need a court-appointed lawyer. Okay? All right. Well, hang on. You're not free to go. Hang on. I got to get some paperwork for you. Oh, yes, okay. You went to This is Mr. Couch for pretrial release papers. All right, this is cause number CR 14460, Michelle Lynn Daly. Ms. Daly, this is a sanctions court hearing. The report that I've received from your supervision office is that you've been extended through July 24th of 2025. And in order for you to successfully complete your community supervision, from now until then, you would have to pay $120 every month. Actually, $170 every month to probation. You'd have to work 170. It says $170 every month to probation. And you'd have to work 10 hours of community service every month until July 24th of 2025. That's to not be revoked. That's not to have a motion to revoke filed on you.
And that's not including court fees,
I don't know.
because I was paying $95 probation, 45 in court, and doing 10 hours of community service until the COVID broke out. And then when COVID broke out, there was, like, it's just now started opening back up to where I can be able to start doing my community service. And I sent some money to my probation online this month, but I wasn't able to pay all of the 95, but I was able to pay at least part of it. And I did 6 hours, 6.5 hours of my 10 hours for this month.
I have a note here that you were also ordered back, this is back before COVID, that you had stopped complying with sanction orders. And then in March of 2020, you were faced with either doing about 9 days in jail or having a motion to revoke filed.
Yes, they explained, I mean, they over to explain that to me. And I did, before COVID broke out, I think it was back in January, or before that, I did a 24 hours in jail that I was asked to do. And then after that, she switched me back to Marshall, closer to where I live. I've been reporting with them every time they've asked me to report.
To me, it doesn't look like you're going to be able to complete your probation.
but there's a little bit away.
Is there a will?
For me, there is, because I'm back on track now, and I know what my consequences are. And it's doing what I gotta do to complete my probation or 10 years, and I can't do 10 years, I have a child. So my child being more than me than 10 years in jail.
I would certainly hope so.
My child more than me than 10 years in jail, so. Like I said, I'm back on my feet now, I'm stable, and I've got my head straight. And like I told Danielle, day before yesterday, when I talked to her on the phone, and she let me know that I had quit today. It's time for me to grow up. I've got a child, and my child came up without some heat all up. I'm home heat now.
How old is he?
He's 12, about to be 13, 12, 13.
Yeah, time to grow up was almost 13 years ago.
I didn't have the support that I have now. I didn't have the support from my mother that I have now. Now that she's with me and helping me, I have that support. I have someone as a backup that can be with my child. I don't have to leave him alone.
So what do you think I should do?
Give me a second chance and let me start paying my fees and doing what I'm supposed to do.
And if you don't, then what am I supposed to do?
If I don't comply, as of next month, if I do not pay the full 170 and do 10 hours of community service, change complete hours, I expect you to revoke my probation.
So you're telling me if I give you 30 days, if I just reset today's hearing
Yes.
and give you 30 days, then in 30 days, you're gonna come back and I'm gonna have a note. Let me finish. I'm gonna have a note here that says you paid everything you were supposed to pay and you did 10 hours community service. And you're telling me that if I don't have that note, then you expect me to revoke your probation. All right. I'll give you that. It's not a second chance. This is probably like a fifth or a sixth chance. We've been way past second chances.
Thank you very much.
So I want you to come back on, what's day? What did you say? So I want you to come back on June 29th. I'm gonna give you a form here, June 29th.
Before June 29th, $170 has to be paid in my probation and 10 hours of community service.
Whatever your probation officer tells you is your due date. I don't know what your due dates are. I need your probation officer to have a note in here that tells me not to revoke your community supervision. That's really what I need.
Yes, sir.
I don't need your probation officer leaving me notes that you're not doing what I've ordered you to do.
Yes, sir.
I'm gonna have you come back at 11 a.m. on June 29th. You're gonna sign here where it says defendant. And so, Ms. Daly, if you don't do what you're supposed to do on June 29th, come back in and pack a toothbrush and whatever else you want to go with you to the jail. Mr. Rosa, come on up, sir, to the middle podium. This is CR 2409 State versus Calixto Rosa. Mr. Manning, thank you for rejoining this morning. I know you were here earlier at 9 a.m. Mr. Rosa was not here at 9 a.m. I appreciate you joining us via Zoom. If you can make your announcement on the pretrial.
Yes, Judge. At this point in time, we're still waiting on evidence in the DWI, unfiled DWI. As I announced earlier this morning, we believe that's going to be dispositive to this case. And so we'd request that the pretrial be reset for us to review all the evidence before moving forward.
Any objections?
No.
Mr. Rosa, where were you at 9 a.m. when we were all here ready on your case? All right, Mr. Rosa, the court's going to reset you for hearing on pretrial on July 1st at 9 a.m. I'm going to have this form for you to sign where it says defendant, and then I'm going to give you a yellow copy. And Mr. Manning, I show that Mr. Rosa is delinquent in his bond supervision and attorney fees. So after that, after you sign this form and get your yellow copy, I want you to report back here to pretrial release, okay? You understand? All right.
Is there anything further you need, Judge?
No, that's all. Thank you, Mr. Manning. I appreciate you.
Thank you. Appreciate it.
You bet. That was Casey Ashmore on Dolphins. So Randy Lee Dobbins, CR 2158 has been reset till July 1st, and the court has appointed the Honorable Casey Ashmore. Thank you, sir. All right, the court has called Danny Mike Dittman, CR 18-7 and CR 2189 Martin Rosendo Perez. Neither were in court when called at 9 a.m. or when their name was called again at 11:23 a.m. Court has had each name called three times loudly and distinctly in the courthouse with no response. Court hereby issues a judgment nisi and alias caveus for each. Here. We ready yet on Mr. White?
Yes, Your Honor, I'm ready on both my cases.
Right, let's go with Wendy Marie Paul, CR 2352, FC 2012. Got to note that she's verified in custody in Kaufman County.
Unfortunately, yes, Judge, she is in custody. of Kaufman County.
And do we know what she's in jail on in Kaufman County?
It is at least one Doe case. It is unindicted. I don't believe she has her family can't retain in Kaufman County, and I told her to request court appointed counsel. She has court appointed. Sometimes things will slow up there. So
Is she currently on a personal bond here in her third-degree drug case? My docket says she's on personal
I
bond.
believe that's correct.
She has, also she has 2 cases.
Yeah, I see that, but I don't have any bond information on the tampering case. I believe it was a county court of law case.
And Judge, it's a PCS 1-4, abandonment or injury of child via criminal negligence. And possession of marijuana less than 2 ounces in Kaufman County.
All right, the court's going to find Ms. Paul's personal bond to be insufficient at this time. Court will set new bail in CR 2352 at $50,000. Court will find her bond to be insufficient in FC 2012 on the third-degree charge of tampering or fabricating with physical evidence. Court will set new bail at $50,000. Let's set Ms. Paul for custody status in Kaufman. Be available on July 1st.
Yes, Your Honor.
Let's set her on July 1st, and I doubt she'll be here, but Ms. Tabraham, if you're listening, I'll need orders finding Ms. Paul's bail insufficient in both those cause numbers. All right, court call CR 283, State versus Jacob David Howell.
Yeah.
Yes, sir.
Thank you.
All right, Mr. Howell, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Howell, you are Jacob David Howell, is that correct?
Middle name is actually correct, but that's okay. Still in Jacob Daniel Howell, but
This is going to get recorded as a alias, and it's going to go down to DPS, and it's going to be on every criminal history. I'd rather, if it's not right, let's make it right.
okay.
So what I'll do is I'll interlineate on this document, or actually, I'm going to give it back. It says David. Everything says David.
I didn't realize that's what we're signing.
See what, I'll interlineate the judgment. I'll let you all fix everything else. Just so that we don't create another alias one.
I think it was an alias, unfortunately. I think that's why I had it.
Middle name is what?
Daniel?
Daniel.
Yes, sir.
Oh, really? Okay, that's fine. It's a popular name, I guess.
All right, Mr. Howell, while we're making those changes, so your name is Jacob Daniel Howell. All right, Mr. Howell, are you a United States citizen? Are you a United, here, come on up here if you will. That's fine.
Yes.
Yeah. All right, and I placed you under oath, correct? All right, so Mr. Howell, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Okay, are you currently on medication or undergoing treatment for that? Do you feel like you have a rational understanding of the proceedings today? Okay, in this case, you're represented by your attorney, Mr. Justin Weiner. Are you pleased with his representation of you? Do you feel like you've had enough time to talk with him about your case and have all your questions answered? Is there anything about this paperwork that you've read and signed that you do not understand? Mr. Weiner, do you believe Mr. Howell to be competent today?
I did that. Yeah, I've heard of that paperwork.
Yes. And have you explained to him his legal and constitutional rights?
I have, Judge.
So, Ms. Burns, you reprinted everything, correct? All right. I'm going to let you shred that. What I'm going to do is keep the last page because he's already signed that. So you can get rid of all that. But he's marked it out. with the date, so. All right, Mr. Howell, you've been charged by indictment with the third-degree felony offense of evading arrest or detention with a vehicle that carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC and a fine not to exceed $10,000. Do you understand that range of punishment? In this case, I see that you have reached a plea agreement with the state wherein you would plead guilty to that charge for their recommendation of punishment at 10 years confinement in TDC, with that being suspended and you being placed on probation for 10 years, a $3,000 fine, court costs, reimbursement fees, and the state appears to be dismissing under section 1245 a possession of controlled substance in penalty group 1 gram to 4 grams, an unauthorized use of a vehicle, and also a theft of property, $2,500 to $30,000. Is that your understanding of the plea? And that's what you're asking the court to approve today. Mr. Weiner, your understanding of the plea as well?
Yes, Your Honor.
All right, Mr. Howell, then to the charge of evading arrest or detention with a vehicle, how do you plead? Guilty or not guilty? And are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty today? All right, the court will accept Mr. Howell's plea of guilt. Mr. Weiner, any objection to states 1?
No, Your Honor.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No, Your Honor.
I'm just going to take a moment to read the office report and evidence, okay? All right, Mr. Howell, the court will follow the recommendation and plea agreement in this case. The court finds that there is sufficient evidence to convict you and does so this day of evading arrest or detention with a vehicle. The court assesses your punishment at 10 years confinement in Texas Department of Criminal Justice. The court will suspend that sentence and place you on community supervision for 10 years. Court orders you to pay a $3,000 fine, $290 court costs, orders you to pay reimbursement fees of $40. The court also takes into consideration under section 1245 F 20-0058, a possession of controlled substance, DA 2020-371, unauthorized use of a vehicle, DA 2020-370, theft of property, $2,500 to $30,000.
If I spoke information about Mr. Howell's physical condition, and his limited abilities to kind of do a lot of things. So I was able to survive.
Remind me what the issue was, what happened to Mr.
Appreciate it, taking time and considering the
All right, Mr. Howell, court hereby remands you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you go with Ms. Burns here for the rest of your paperwork. I need you to step over and be fingerprinted with the deputy. Good luck to you, sir. Yes, sir.
I may or may not appear via Zoom this afternoon, so if
What do you got?
just one person message.
Nothing that's going to be a plea that requires, yeah, no problem. No problem.
Kind of ping pong ball today.
Understand. Thank goodness Zoom allows you to ping pong.
What's that?
I said, thank goodness Zoom allows you to ping pong a little bit.
Especially usually I'm in Free County, so I want 30, and it's nice to kind of be everywhere. So hopefully we keep that.
All right, I believe that does conclude the court's morning docket. Court has issued judgment nisi and alias capias for those who have not appeared. Sure. I show that Jennifer Lynn Gonzalez has a warrant. Do we know on, let's go with Sergeant Carter, do we know on Jennifer Lynn Gonzalez if the warrant is associated with this case?
I'll go to the facts.
All right, the court's going to conclude its morning docket, and we will resume at 1:30 at the Van Zandt County Justice Center and also on YouTube.